I do want to announce in advance that we have at least two of our organizational plaintiffs with us now. I'm looking at the names that pop up, and so we're going to give Reverend Ward an opportunity. Reverend Ward is the pastor, or at least I'm not sure exactly what your title is, but he is the person who we met with him and his board, and they took the courageous and correct step to join this lawsuit. They are the Mission Peak, a Unitarian Universalist congregation in Fremont. So we're going to let him say a few words, and then we're going to call upon Donald Whitehead Jr. Donald is the executive director of the National Coalition for the Homeless, which is probably the most recognized advocacy organization.
Recording in progress.
In the United States on issues of homelessness. And we've had excellent relations with them down through the decades, and even closer than ever in the last 2-3 years, and teaming up on projects and watching as this intensified war on the homeless that we're meeting it with a unified collaborative approach to beating it back. Bob, welcome aboard, and I'll explain right now to everyone now before we actually get started with the press conference. Bob was one of the plaintiffs in the lawsuit that we brought in Fresno almost 3 years ago that has some similarities to what we're fighting now, and we've succeeded in getting an injunction in that case and getting the Fresno City Council to repeal that very problematic repressive ordinance. Of course, they're all back on the warpath now because they think they have a green light with Grants Pass. But Bob, it's good to see you and hold up the role that you played. Bob's been publishing a people's newspaper there for decades, and I guess still at it. So it's good to see you, Bob.
Yeah, thanks. Mike Rhodes actually the publisher, right? He's been doing it for decades.
Yeah, that's right, Mike. Yeah, Mike, that's right. Yeah.
I write for the paper on these kind of issues.
Well, your name was
I appreciate all the work you guys did on that case we had here. That was a great victory. Thanks.
It was. Yeah. Okay, I want to introduce myself first of all. My name is Anthony Prince. I'm one of the organizers and the general counsel for the California Homeless Union, a statewide organizing council, as well as the National Union of the Homeless. The purpose of tonight's press conference is to familiarize the members of the media with the most recent developments in this case and in the situation in Fremont. I want to say from the outset that we had a press conference Friday night, and over 106 people participated in that event. But unfortunately, we had sent out, in some of the announcements, carried a Zoom link, which was the incorrect Zoom link. And so we know for a fact that many people that would have joined us on Friday were unable to do so. And that's one, especially media representatives. We are very thankful and mindful of how important the news coverage has been in this case. It has received a great deal of national coverage in California and all over the country. And we're grateful for that coverage. And so we wanted to accommodate those who couldn't make it on Friday because of our mistake to have another opportunity to ask questions. I want to let everybody know that we recorded Friday night's press conference, and we're going to make that available. There's both a written summary and there's also the recording. And we're going to make that available, and I would encourage you to look at it because a great deal of information about the ordinance, about the false misrepresentations that the city has put out, and what the objectives of the plaintiffs are. So I'm going to give my email for that purpose. It's princelawoffices@yahoo.com. I want to say two things. One, that if people contact me at that email address, we are happy to talk to all those who are interested in this case in terms of reporting it out or becoming part of this case and supporting the homeless community and the advocates for the homeless in this very important case. So we'll have the privilege and honor of introducing our most recently added organizational plaintiff, and that is, and he'll speak in a moment after I introduce him, Donald Whitehead Jr. has been in the trenches a formerly homeless person himself, who was able to emerge from that situation and become one of the undisputed leaders and advocates for the homeless in the United States for the last almost 40 years. Donald is executive director of the National Coalition for the Homeless, and our National Union of the Homeless and the National Coalition for the Homeless were formed about the same time and came out of, in many respects, came out of and helped organize the March for Housing Now in 1989, which drew 250,000 people in Washington, D.C. We are absolutely thrilled that the National Coalition has decided to become an organizational plaintiff in this case, and we will be adding the name of that organization to the case caption as soon as we can. Don, I'll tell you that the decision of the coalition to become make the walk meet the talk and become a plaintiff in this lawsuit has already inspired other organizations to contact us about adding their organization on the plaintiff side of this case. So without any further ado, I'm going to call upon Donald to give us his take on this situation and why it is that the National Coalition feels that it was important to become involved. Don?
Anthony, thank you so much, and thank you for putting this press conference together, and thank you even more for this lawsuit to block what we see as an egregious action by the city of Fremont. We want to thank Priya for bringing this to our attention initially, and we have been working on the issue of homelessness since the late 70s, early 80s. We actually started on a civil rights platform. We actually won the right to shelter in New York. We actually drafted the McKinney-Vento Act, which is still the primary source of funding for homeless programs across the country. It is in our DNA, it is in our mission and our goals to make sure that people's rights aren't being violated while we work on an end to homelessness. In this case, we have seen the limits of how dark a community can be. We've seen the limits to how compassion and the lack thereof is the order of the day in so many communities, and this particular issue harkens back to the the slavery movement and the slave codes, which were of the very same principle that people would be arrested for aiding and abetting people that were runaway slaves. And so, again, we're darker and darker since the Grants Pass Supreme Court case. We've seen over 160 communities across this country enact laws and ordinances that basically make it illegal to be homeless, although none of those communities have enough shelter to meet the needs of the population. As this has grown, we've also seen a tremendous growth in the number of people experiencing homelessness in this country. Over the last 2 years, homelessness has increased by 30%. And the most ineffective strategy is criminalization. At the end of the day, criminalization does not result in the end of homelessness for the individual who is criminalized. So every time we jail, fine, or ticket a person experiencing homelessness, we make that path out of homelessness just that much harder. So we are committed to being a partner with cities across this country to make sure that in the richest country in the world, that we do not treat people the same way we treated people before the Emancipation Proclamation. And that's it is not hyperbole to talk about these issues in these terms. And this is one of the most egregious, but we see these kinds of cases across the country that just make you really shake your head and wonder where we're headed. In Kentucky, you can use force, up to and including deadly force, if you encounter someone that's homeless on your property. In Tennessee, it's a felony with up to 6 years in jail if you're a person experiencing homelessness on public property. So more and more, we see the ante going up. We see the penalties getting worse. And now we're penalizing people that have enough compassion to help someone. So it is so important. We are a membership organization, and we and our members are committed to doing whatever we can to ensure that this kind of activity stops. California, it's rampant in California, the criminalization of people experiencing homelessness. Again, it is an ineffective approach. It does not end homelessness, and it actually exacerbates the ability for a person to resolve their homelessness. They're now ineligible for housing, ineligible for jobs. They've lost their connection with the social service network. They lose medical devices. All of these different issues happen when we start treating human beings who have no other choice but to sleep outside because we as a country have not provided the resources necessary for them to be housed. We won't stand for this, and we stand with the city of Fremont and the Homeless Union and all of the other plaintiffs in this case to ensure that we push back and we stop this kind of egregious activity once and for all. Thank you very much for having me.
Greg Ward is with the, as I said, the Mission Peak Unitarian Universalist congregation in Fremont. And of course, if people are familiar with the history of the Unitarian Church, you know that it is no surprise that they would be on the front line and taking the courageous stand that others have not yet taken. But we answered questions, put questions, and they made the decision. So, Greg, if you want to say a few words and explain why you feel it was important for your congregation to become part.
This is a landmark moment in the city of Fremont, but also in the country as a whole as we're responding to the Grants Pass decision. By the way, my name is Reverend Greg Ward. I am the lead minister at the Mission Peak Unitarian Universalist congregation in Fremont. We have for some time now been trying to carry out our mission as a congregation, which is a lot like missions of churches all over this country. We feed the hungry, we clothe the naked, we visit the sick and imprisoned, and we have developed a relationship with the unhoused people in Fremont. We have currently 650 unhoused people in our city. We have 159 shelter beds. The decision that came out of the Supreme Court in Grants Pass case stated essentially that it is okay, it is not considered cruel and inhuman punishment for police sweeps to go and break down and disperse encampments even if they have no other place to send the unhoused people. There is an African proverb that I have been calling to people's attention that people don't become homeless because they run out of money. People become homeless because they run out of relationships. And they also run out of relationships with compassion. Fremont has long called itself one of the happiest cities in this country. It has been designated as a compassionate city, one of only 70 globally that has that designation. They had to earn that designation, but nothing that they're doing in this case is emblematic of any compassion whatsoever. So we're really glad to join with Pax Christi, Northern California, and Faith in Action, East Bay, as well as the homeless unions of California and nationally. We think that this is a moment that people all over the country need to pay attention to because it is signaling the direction that we're going with respect to taking care of the people who need care the most.
We had a scheduling conference that took place last week between the city attorney, myself, my co-counsel Andrea Henson, and Judge Maxine Chesney, the district court judge that's been assigned to the case. And the decision that came from that meeting was essentially that the city, which is now planning to amend the ordinance, and it's indicated they'll do so by striking the language in chapter 8.90 that uses the terminology aiding, abetting, and concealing as a basis for a criminal charge against persons who engage in activity which is deemed aiding, abetting, or concealing a violation of this anti-homeless ordinance. Depending on what the city does, and we know what the city is going to do, it is then the obligation of myself and Ms. Henson as counsel for the plaintiffs and the city attorney to sit down and work out a briefing schedule, meaning that dates will be set for an opposition. The city will have a chance to oppose the motion and the complaint that we have filed. They'll file an answer to the complaint, and more than likely in opposition to our motion for an injunction. There has been no injunction issued at this point, but the city has agreed to pause enforcement of the ordinance, which became law on February 11th. I'm sorry, it became enforceable on actually March 13th, or will become enforceable on that date. But there are a few more days to the city council meeting set for the Tuesday, March 18th. We do expect that as soon as that becomes effective, that we will be able to file a appropriate motion in the court to enjoin the enforcement of that ordinance. The amendment that they're considering, or that they're going to make in deleting that language from section 8.90 is a facade. It is a fraud. It is a trick. It is an illusion, because the very same aiding and abetting language, the exact same words, the very same words, are already in the Fremont Municipal Code in the very first chapter of that code. And if you don't already have a copy of the complaint, we'll send it to you, and we put it into a footnote on the second page, right after in the introduction. It's quoting the chapter 1.10.040, which reads, "Whenever in this code any act or omission is made unlawful, it shall include causing, permitting, aiding, abetting, suffering, or concealing such act or omission." So from a legal standpoint, the net effect of them removing that language from the ordinance 8.90, the code section 8.90, is nothing. The city retains not only the ability, but I would argue the obligation under this code section to prosecute someone who assists another in committing a crime. So as long as the being a homeless in the city of Fremont, and by way of the definitions they've given to camping, to camp, to paraphernalia, to facilities, anyone who allows an encampment to be established or maintained, and the definition is so broad and is so sweeping that we feel it's appropriate to find it unconstitutional on its face. So with that, I think the only thing I want to announce also is that we're going to have, and maybe Priya, I don't know if you want to go ahead and handle this part, if you want me to address it. Priya's with the Fremont for Everyone organization. And what we're going to do is initiate a citywide, or really a countywide petition to the city council demanding that they suspend enforcement of FMC section 8.90. Priya, did you want to talk about that, or?
Yeah, sure. So we just want to send a letter to the city council and have organizations sign on and make clear their stance that even with the aiding and abetting clause removed, that they do not support this ordinance. And so we just want to we are asking organizations to sign on to a letter, and if you're interested, you can put your email in the chat and I'll reach out to you, and this is a letter we'll be sending to city council before the meeting on March 18th. Thank you.
Thank you, Priya.
And just to clarify, I'm acting outside of Fremont for Everyone, and just as an independent community organizer.
Okay, well, I would say that you qualify to be entitled yourself more than an independent community organizer. Priya really stepped up in a significant way. I'm going to read what the petition letter says, but I want to show you this photograph that is part of it. And if you can make it out, that is a photograph that was taken, I believe, yesterday. And it depicts a wheelchair, and on the wheelchair is a notice of nuisance and an order to vacate, and a warning that that wheelchair will be removed. The person who needs that wheelchair in order to survive and get around was not present when this tagging took place. This woman is a disabled, hearing impaired female. This is what it's come down to in the city of Fremont. And the code sections that are cited to in there were not actually violated by the fact that this woman had her wheelchair not in a park, but in a parking lot. So that's a violation of an existing ordinance. Under this new ordinance, if they're allowed to put it into effect, she would be violating it simply by having that wheelchair in a public place. All public places will become off limits and will be subject to criminal enforcement if we let this thing go through. So I'm going to read this. It just says, we, the undersigned members of the Fremont and Alameda County charitable community, cannot and will not abandon those that we are moved by conscience, faith, and community to assist. We cannot allow tents, tarps, sleeping bags, blankets, and other means of survival to become instruments of criminality under Chapter 8.90 of the Fremont Municipal Code. It is not enough that the aiding, abetting, and concealing language might be taken out of the ordinance, because the all-encompassing Chapter 1 of the Municipal Code uses the exact same language. How can we provide a tent, tarp, sleeping bag, or other contraband to homeless residents, knowing that as soon as they use these items, they could go to prison for 6 months? We therefore demand that the City of Fremont suspend enforcement of FMC Chapter 8.90 until the court can determine whether or not the measure is unconstitutional. Further demand that in the interim, the city accept the invitation of the Homeless Union to come to the table now and seek an agreement that will balance the interests of the city, the faith community, charitable organizations, and our unhoused residents. So
you mentioned some of the timeline, but what are the expectations in terms of getting an injunction to overturn this? Because it's a Rosa court, it's going to take a long time, right? I mean, if it goes to the Ninth Circuit ever, then is this a trend? Do you think if they're getting away with this in Fremont, do you think it'll set off a trend in other cities? And then my other question is, how does the case we won here in Fresno that people don't know, the city was trying to bar advocates and members of the media from being near encampment sweeps when they occurred. Anthony fought that and we won, but because I'm both an advocate, I pass out tents, I do stuff like that. So could that impact? Could it come to our city or other cities soon? Because this is messed up.
Yeah. Okay. Let me answer that. You asked 3 questions, Bob. And the first, you're absolutely right. Sometimes a civil rights case or any case in federal court can drag on for a considerable period of time. That's why we're not simply filing, or we haven't just simply filed a complaint. We have also filed a motion for a temporary restraining order and a preliminary injunction. And those are heard in short order. Courts normally will rule on a motion for a temporary restraining order within 48 hours. That's been our experience in all the cases, most of the cases that we have brought in California. On the other hand, sometimes what will happen is the court will convene a hearing that they say, well, let's give the other side a chance to answer, and they'll have a hearing, and then the court will rule based on the court will rule on both the papers, the briefs that each side files, and on the oral argument. We anticipate in this case, you're right, we have no intention of waiting months, weeks, or years, certainly, to stop this thing. So that's why we're going for an injunction. We think we have a good shot at it. We think we've met the elements to obtain a preliminary injunction, and we're proceeding on a theory that is different than the theory that was advanced in the Grants Pass case. That case was a law similar in its cruelty to what we see in Fremont, but it was challenged on the basis of the Eighth Amendment, which prohibits cruel and unusual punishment. And unfortunately, the Supreme Court felt that ordinance in Grants Pass was not cruel or unusual, and therefore they ruled on the side of the city of Grants Pass. We have consistently advocated around the 14th Amendment. 14th Amendment includes a clause of substantive due process, meaning that you can't be deprived of life, liberty, or property without due process, and you have the right to bodily integrity. And based on the 14th Amendment, there is a legal doctrine called state-created danger. And that's when the government acts affirmatively to increase the risk of harm to a person or persons. In other words, that they act in such a way as they have worsened and increased the risk that was, in other words, made it worse for them by some act of government. Here, and we've argued this successfully in cases here in California, that the city is going to take people that are in the park or in the parking lot or on the street or in an area, some public area, where they may, in all likelihood, have a tent, in all likelihood, have some food in there, in all likelihood, are getting support from the community, in all likelihood, have caseworkers in there trying to get them on, in many cases, a path to housing, and they're going to criminalize their very existence. They will not let them be in a tent. They will not let them be in possession of what they call camping paraphernalia, which is everything from a blanket, a tarp, a tent, a bedroll, you name it. And the list of the definitions they provide in this ordinance list these various items, and they use the phrase including but not limited to. So what this ordinance has done is the city council has empowered itself to add to that list. It's an open-ended definition, and so it's a very slippery slope. The second question, Bob, and you asked if this is a trend. I think we heard from Donald Whitehead just now from the National Coalition that in Tennessee they have made it a felony, and in Kentucky a similarly, I would say, obscene criminal ordinance against the homeless. So already we see the trend, but I think the distinction here, and again this is also about Fresno, and what happened in Fresno, which we successfully defeated, was a measure which would have given the police or any city representative the unilateral authority to simply put up a cordon, a physical cordon, a barrier around any area where the city was displacing and removing a homeless encampment. And so we challenged it on the basis of the First Amendment. Obviously, the press was very concerned because they wouldn't be able to cover and inform the public about these acts. Our union, we have a Fresno local union. We have a Fremont local union too. But in Fresno, our local union there would have been physically prevented by this cordon from representing, advocating, and witnessing and taking care of our members and protecting their rights. And so that went forward with the First Amendment, free association. People have a right to join a union for their own benefit, and the union, the organization itself, has a right to discharge its obligations to its members. So on those bases, the court issued an injunction, a strongly worded injunction, finding that the city had violated the First Amendment, ordered the city not to enforce that ordinance, and about 3 months later, the ordinance was completely repealed. It was a very significant victory. Now, again, Fresno, like a lot of these cities, think they have a green light now with Grants Pass. But as we pointed out consistently, that is not true. And if you look at the decision itself, if you look at the Grants Pass decision from the Supreme Court, it expressly states that there are other avenues of approach to challenging these types of measures, including the 14th Amendment. So even here in California, Governor Newsom issued a public statement shortly after the Grants Pass decision, and he said there are no further restrictions on cities. And the governor expected cities and warned cities that if they didn't start clearing these encampments, they were putting whatever state aid they might be entitled to, or by way of housing the homeless, they would not get it. And so that was a false statement from the governor. But unfortunately, a lot of cities are citing to Grants Pass, including the city of Fremont, has cited to Grants Pass as the justification, or one of the legal justifications for going forward with this ordinance. So I think that what happened in Fresno, they had a physical cordon and gave the police untrammeled authority to set it up. In Fremont, we have a codified cordon, we could call it that. They have codified the measures that they empowered their police to take in Fresno. And so in some ways it's far more dangerous because it's been put into, in black and white language, into a municipal code, this very thoroughgoing and extreme criminalization. So I think hopefully I've answered your three questions, and if not, we'll probably touch on some of these things when we get further in the press conference.
And Anthony, if I could just add really quickly, we do see a lot of copycat ordinances when one of these things gets passed. We actually saw the same kind of ordinance in Florida back in the early 2000s, and this was about helping people to eat. So it was a food banning ordinance. They actually arrested a 80-year-old pastor, Arnold Abbott, in that case. And so we saw a lot of attempts at food banning during that time. And prior to that, we saw a bevy of ordinances around panhandling. Most of all of them have been defeated, and we've recently started to see more victories when it comes to at least the criminalization ordinances in Iowa and in Indiana. Just this past week, we saw two of those get pushed back. But what I will say is that there's an organized effort to put these criminalization activities in place by some well-funded organizations, and so it's really incredibly important that we take a stand and use the Constitution as a defense for these kinds of actions. And Anthony's absolutely right. In the opinion in Grants Pass, it was stated that there were other means to be able to address these issues. So we're very grateful that organizations are really taking the time to fight back and not just taking this as law. But there have been 160 plus since the Grants Pass issues. So we would probably see a lot more of these anti-compassion ordinances if we don't fight against this one.
I want to just emphasize that the ordinance simultaneously criminalizes those who would assist homeless people, because they've criminalized the use of the very items of support, material support, and survival that a lot of the charitable organizations provide to the homeless. So it's impossible to have one without the other. It's impossible for anyone to say that the charitable organizations are now free to carry out their mission, when in fact the tent that you hand over as a protective item of protection becomes a instrument of criminality. That homeless person can have that tent, but the minute he sets that tent up, goes into it, puts his clothing in it, puts his food in it, has privacy in it so that he can put on those clothes, he's a criminal and subject to arrest. So it is impossible, and it defies logic to think that the city can now claim that the providers of this relief and material support to the homeless are now free to carry on their work. It's simply not true. On the 18th, we are calling for a mass rally and protest at City Hall, and we hope at that time to be able to present these petitions with the signatures of dozens, if not hundreds, of organizations, community groups, churches, congregations, and just well-meaning citizens in the city of Fremont demanding that this ordinance not be enforced. So
my question is, if the city council takes an action on the ordinance referral on March 18th, if there will be a second reading at a second city council meeting before the ordinance is enacted. In other words, we're wondering when the clock would start ticking on enforcement of the ordinance.
that's an excellent question, and to answer it, we are looking at that. There's reason to believe that they would have the obligation, and so far our legal research shows that the amendment to an ordinance is treated the same way as the ordinance itself, even if it's in effect. We had a somewhat similar situation in Novato, California, where we had, again, a question of an amendment to an existing ordinance, and I believe in that situation, they had to follow the first reading, second reading, and whatnot. But we're not certain about this situation. The ordinance was enacted on February 11th. It became operational or will become. It would have come into operation on March 11th, or it's scheduled to come into operation on March 11th. They've voluntarily agreed not to enforce until at least March 18th. But we don't know at this point exactly how we're going to frame that. But we're aware of that, and if there's some way that we can force that process to be undertaken, we will. And it's for the purpose of just gathering more support and giving us more time to build up the kind of community pressure that seems to be now moving in this direction. But we're not certain. But you can be confident that if our determination is that the city has that obligation, that we will definitely make that an issue.
Really quickly, I'd just like to add, as Western Regional Co-Director here in California, we are seeing a collaborated effort throughout the state to enforce these different ordinances. A lot of them are going by very quietly, and especially in a lot of these more conservative towns. We're seeing about 10 ordinances that are anti-homeless ordinances in every city in California. Here in Sacramento, the capital, they claim to be very progressive. We are seeing entire encampments being arrested over coordinated policies that have been coordinated through different entities that have coordinated the same type of ordinances like in LA. So exclusionary zones, things like that. And so people need a place to exist, and we keep hearing this, this wording of we need more tools in our toolbox. The tools that they need to put in their toolbox is housing and to prevent people from dying on our streets.
That's correct. And I see Greg shaking his fist there. That was a good point. And if people don't know, and I see some people here that have contacted us from cities other outside of California. I see from some of our housing justice fighters from Minnesota on this right here, and I see some of the fighters from other parts of the country. What we did in Sacramento in 2022 and 2023 is very instructive in this case, because as some of you remember, or some of you experienced in the summers of 2022 and 2023, we had an unprecedented heat wave where in one case we had 10 uninterrupted days of triple-digit temperatures. And what the city of Sacramento was doing was that they were conducting sweeps and breaking up homeless encampments that were in the shaded areas, in some of the parks and the shadows of buildings, and they were kicking the homeless out of those areas into the path of direct sun and direct heat at the risk of their lives. And so we were able to get, over a 2-year period, 4 consecutive preliminary injunctions halting the city from that practice. It was textbook state-created danger, because they were taking people as they found them and then increasing the risk of harm by affirmatively evicting them from the area in which they were found. And so that was a tremendous victory. They appealed that all the way to the Ninth Circuit, and the Ninth Circuit denied their appeal. More recently, we had a decision in Vallejo, California, And in Vallejo, we had a 64-year-old woman who has significant disabilities, and she had been able to build herself a home. And we see this more and more now across the country. And I think that's one of the reasons that the city of Fremont is particularly focused on tents and huts and structures, because more and more homeless people are protecting themselves and seeing to it that they can survive, especially as the climate worsens, as we see the effects of global warming and the intensification of storms, summer heat, winter extreme temperatures, and storms. And so and the demographic of the unhoused is also changing and rapidly expanding and becoming more diverse. And we've had cases where construction workers, homeless construction workers, people who build homes for a living and yet are homeless. And so when they become homeless, they know how to put a home together. They know how to get that drywall and get those 2x4s, and they know how to make that happen. And Miss Evelyn Alfred in the city of Vallejo did that herself with their own two hands, built herself a place to live. And so the city of Vallejo, because they thought they had a green light from the Grants Pass case, tried to evict her. We have a newly formed homeless union local in Vallejo. They took up the challenge. We came into the case, and we got an excellent ruling in February, just last month, from a federal district judge in the Eastern District that found that the city of Vallejo was violating Miss Alfred's 14th Amendment right to be free of government conduct which increased the risk of harm to her. And so it's our understanding that we got the first federal injunction since Grants Pass. We were the first in federal court anywhere in the United States. And we are now getting inquiries from across the country as to how we were able to do that. And that is the approach that we're taking here in Fremont. And we're going to rely on those cases that we helped bring about, and those decisions that we were able to obtain from these district courts as persuasive authority in this case. So we know how to fight, and we think that we have the law on our side here. And so we're going to go forward both in our organizing, our political organizing, our community work, and in court. We're in the courthouse and we're in the court of public opinion, and they're equally important.
Hi, I joined in a little bit late, so I'm sorry if I missed this. I was just trying to get clarification on a couple of things. The lawsuit was filed last Wednesday, is that correct?
We filed it on March 4th. That's correct.
Okay. Got it. And then I heard you say that I know the city has agreed to pause the ordinance for now. When it does become effective, did I hear you say you were going to file an injunction, or did I mishear that? Let me explain. Yeah.
We have already, within the body of our complaint, we have it's two things at the same time. We have filed a 42 USC United States Code Section 1983 civil rights complaint, and we've also citing to other federal and state protections for people with disabilities, for people who are in protected categories. So we have our civil rights lawsuit, and that will go forward no matter whether we get an injunction or not. But we've also filed within the complaint, we have sought injunctive relief, and we've spelled out the elements necessary to get a preliminary injunction. What the court indicated was something that we could pursue was filing an amended motion for a temporary restraining order, preliminary injunction. And I think the court's thinking was that we may not be happy with what with what the city does on March 18th, and I can tell you right now we won't be. And so we're pretty confident. We do expect that we will immediately go into court and seek an injunction, or see if we can get the court to schedule a hearing based on the injunction that we filed with our complaint on March 4th. One way or another, we're going to try to get as soon as possible some kind of order from the court enjoining the city from enforcing this ordinance. But I also want to let you know that we have made a formal invitation to the city. I spoke with the city attorney on Friday, Mr. Alvarado, and let him know that we want to come to the table now. And what we did was we proposed that if the city would voluntarily suspend enforcement of the ordinance, and we would pause our litigation and not seek a ruling for a preliminary injunction, if the city would agree to suspend enforcement and come to the table and sit down and meet with us, meet with all the plaintiffs in the case who have a stake in the and are both the homeless themselves and those who would be supporting the homeless, and talk about the issues. The city's primary justification for this ordinance, they claim, is public health and safety. We see that all the time. That they'll characterize, in some cases, grossly exaggerate issues of safety and health within encampments, and in some cases the threat that they say the existence of homeless encampments threatens the community at large. Okay, let's talk about what those are. We are no less interested in safety and health than the city claims that it is. We are about public health and safety that includes that segment of the public that are unhoused and are safety issues that they face and will now face at an even more extreme level if this ordinance is enforced. We invited them to come to the table. You're talking about issues that we're concerned with, that we think we have some solutions for, but we also want to make the city aware of its obligations to uphold the constitutional rights of all of its residents, and not simply use health and safety as a shield and a cover for violating those rights. So I'm saying this because on the one hand, we're prepared to do what we have to do to stop the city's enforcement. On the other hand, we're willing to set aside litigation if they agree to come to that table and for some indefinite period of time and engage in meaningful discussions. None of these policies are ever enacted without consulting and meeting with the homeless themselves. These are policies and dictums and measures that are taken as if homeless people are not even citizens, are not even members of the community, that they're not respected, and even to the point of, well, we're going to have a policy that affects this segment of the population, let's talk to that segment. That is not taken into consideration in enacting these measures. And so what we're saying is simply, let's sit down. We have things to talk about. We think we can address the health and safety issues. We think we can address the issues of survival and of the need for seeing to it that the city of Fremont, the statistics don't include the deaths of homeless people, which we see increasing, the shortening of lifespans, and the increased deleterious, irreversible health effects of being homeless with no means to protect themselves. So we have not heard back from the city. I did not hear from them today. Tomorrow I will reach out and see if I can get a formal answer to our invitation. We have been able to do this with a couple of cities. We've been able to sit down, get settlements, and get agreements. Some have lasted a few weeks. Some have lasted 3 years. We had another one in Novato that went on for 2 years. And in every single time that we were able to reach an agreement to keep an encampment in place, we've made those encampments safer, made those encampments healthier, and most importantly, they become staging grounds for permanent housing. The homeless encampments have become staging grounds for permanent housing. It's impossible, as people have pointed out. How are you going to find housing for someone that you can't find, who's hiding for fear of being criminally prosecuted for living in a tent? So we hope that the city of Fremont will live up to its membership as one of the 70 compassionate cities. And we're going to look into that. We're going to look into exactly what that process was and how it is that they qualified for that. And we hope that they'll return and be deserving of that title. But either way, we're going to do as whatever's necessary to protect our members and the broader homeless community, and protect, for that matter, those who are perched on the edge of homelessness. Because now the fastest growing segment of the unhoused in this country are retired workers, baby boomers, families in the weekly rate motels, there because they fear having their children in the encampments. I saw an item in the paper the other day that Disneyland employees protested and picketed because they're not earning enough to live decently. 3 years ago, we saw graduate teaching assistants go on strike throughout the entire University of California system because they weren't earning enough money. These are people with PhDs who can't afford to live in the city in which they're teaching at a university, in a university setting. We had members of our homeless union who were sleeping in their cars in the University of Santa Cruz parking lot. And so the demographics changing. We're seeing more and more people falling into homelessness. We saw fires in Los Angeles that made thousands of people homeless instantly, and rich, poor, in between, whatever circumstances, no one is safe from becoming homeless. And so what's at stake in this case is a lot more than what the city is trying to represent is at stake.
So Anthony, you have Bob's hand up again?
Yeah, I got it. Okay, Bob, another question?
Yeah, just a quick question. I know there were some cases at the border. I think the group was called Border Angels or something like that. They were basically giving water and food to people in the desert that had crossed illegally. I know it went through the court system, and I believe they won plaintiffs. But I don't know if you're looking at those kind of cases, but as precedent setting. But
yeah, we're aware of that. And
is that going to help us?
To the extent that we have rulings, especially in the appellate courts, which are controlling authority, but even if we have lower court rulings in the district courts that have found that the deprivation of water reached a constitutional was a constitutional violation, then that will be extremely helpful. And we are looking at those cases. And
people pumping out water during the summer and the heat, you know.
Yeah, well, that's exactly what happened to our people in Sacramento. They were deprived of the ability to. They were told to breaking up these encampments. Take your things with you. Well, how can you take all your things with you? I don't know if anyone's ever weighed a gallon of water. It's very hard to tote it around a city when it's 100 degrees, 101 degrees, carrying a gallon of water. That gallon of water is not going to last long. And so we are going to look at those cases. And I should say at this point that the what we see now with the immigrants, with the undocumented workers, and this concentration now at the very top levels of the United States government to intensify the sweeps and the displacements. The homeless are undocumented too. The homeless are undocumented workers too. Their IDs have been taken by the police many times. They don't have a lease. They don't have that document. They don't have a deed to a house. They don't have that document. They don't even have a document that says that they're permitted to stay in a shelter and protected from an eviction without due process. So they're like us. We're like them. They're people who are homeless. We're homeless. They're people who are being persecuted and pursued, just as we are. And they're people that are being blamed for every problem in the United States, just as the homeless are being blamed for crime and for endangering the public safety. So we make common cause with our sisters, brothers, our siblings, who are facing that challenge from the federal government, and in many cases from some of the state governments. But that's an excellent point, Bob, and we're definitely looking at those cases, and I think they will be persuasive. We did hear from NBC Bay Area, and we heard from our first news outlet, and we've heard from members of the community, and we are our own media. Let's not forget that. The conversations we have, the meetings that we call, the social media, the community papers, the church bulletins, the handheld cell phone video, these are our media. And so we lift up not only the traditional media, but we lift up the citizen journalist who is documenting the fight that we're making. And I'll just close by saying that Grants Pass was a small town. It was a small town, and yet a small town made history in the wrong direction. We have a chance here in Fremont which is a little bit bigger, but no less a city, one city out of hundreds in the state of California and millions across the United States. We have a chance now to make some history in the correct direction, in the right direction, towards justice, toward the preservation of our rights, and towards housing for all.
For a second, this is Herman with the Sacramento Environmental Justice Coalition.
Yes.
You know, our extreme weather here in the valley is going to cause all kinds of havoc with people on the streets, let alone folks that cannot get ID. We're working right now with an elderly and disabled woman, and with this real ID business where everybody's required to have it after May, it's a backlog in DMV where folks cannot get identification properly. This is a major concern of ours, because this is a person that's elderly and disabled, and they can't navigate that new requirements, let alone go to, this person happened to live very far when she was where she was born, and now she's here in Sacramento, and getting that birth certificate has been quite a journey. We're navigating it for her. We're not a direct service organization, but we imagine this is going to happen to millions of folks who just will not be able to have a real ID. And like you said, with the unhoused population, it's the same challenge. And the money that it takes to get all the real birth certificate and marriage licenses, all these things get in the way of getting identification these days. It's been quite a challenge. I imagine this will be the same challenge also for just registering to vote. It's a major hurdle right now.
We actually, I want to point out that is an excellent point. And we have looked at this question of the voting rights. That as you may know, there was a time when if you didn't have a fixed, stable address, you were not permitted to vote. And the voter registration form required you to identify and write down your fixed, stable address. And our union was one of several plaintiffs in lawsuits that were filed in the early 90s, that actually won the right to vote expressly for people that did not have a fixed, stable address. And if you look at the voter registration form now in the state of California, it has a provision. You can put your address if you have one, or you merely describe the location. Where are you located? But now that right to vote is being challenged, because if you're removed from a location, you can't even identify a location. A city has made it impossible for you to even be in that particular municipality. So you can't even describe the location you're in, at least to be able to vote and have a say so in policies that are going to affect you. I'm gonna single out one more journalist here and see if we can get a question from her. But if we don't, I'm still going to single her out. We have Nikki Silverstein with us, I see, and Nikki is a reporter for the Pacific Sun paper. She has managed to write articles that are absolutely objective and fact-based, and yet at the same time, because they're truthful, they've helped us make the case for justice for the unhoused. And so I just wanted to recognize Nikki and others who have done, I have to say, I've seen some outstanding journalism around this case and many of the battles that we've fought. And Nikki's one of the first among equals in that regard. So Nikki, I don't know if you have a question for us, or certainly welcome to ask it if you have one.
Nope, I think I have a pretty good understanding. Thank you for holding the conference.
Okay, thank you. Thank you for joining it. Okay, so with that, I appreciate everyone's participation. Again, media or community members who want to get a copy of the complaint and want to be kept abreast of what we're doing, especially with the community petition, should reach out to me, and I will then farm it out to other officers of the union and our legal team. And so you can write at Prince Law Offices, PRINCELAWOFFICES, all one word, at yahoo.com. And so with that, I want to wish everyone a pleasant evening, and thank you so much for taking the time to hear us out. Good night.
Good night.